I'm going to call Henry Johnson to stand, please.
Mr. Johnson, would you raise your right hand, please, sir? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. Mr. Mann.
Thank you, Mr. Chairman. Mr. Johnson, would you please state your full name for the record, please?
Henry Stewart Johnson.
Are you employed?
Yes, I'm the Commonwealth Attorney for Harlan County, the 26th Circuit.
How long have you served in that capacity?
Since late January or early February of 1992.
Mm-hmm. How long have you been licensed to practice law in the state of Kentucky?
Since 1976.
Mr. Johnson, in your capacity as Commonwealth Attorney in Harlan County, did you have occasion to prosecute 2 criminal cases with 08 case numbers against 2 physicians who were charged with selling illegal narcotics in Harlan County, Dr. V and Dr. Lalani?
Yes. Now, actually, they were selling the narcotics in Nashville, which were then being brought with their knowledge to Harlan County and sold illegally.
Thank you. Thank you. During the course of the prosecution of that case, did discussions over a plea agreement for Dr. V and Dr. Lalani take place?
Yes. And
specifically, I want to refer you to the time frame of late 09 heading into early January of 2010. Does that refresh your recollection?
Yes. Plea negotiations were going on at that time, and it resulted in a plea on January 11th of that year.
And can you please outline for the members of the Commission any discussions you had with Judge Russell Allred regarding the plea and the terms under which that agreement would be pled?
Right. At that time, there were 2 defendants, and they had 6 attorneys representing them. There were 3 Kentucky lawyers and 3 Tennessee lawyers who represented them. They lived in Tennessee. It was an unusual case in that they had never actually come into Kentucky, and we were using a statute that grants jurisdiction extraterritorially when they knowingly do something that causes a crime or damage in Kentucky. Do you want a more history? Or am I
no,
just okay. Okay. Now, as far as the plea negotiations go, at this time, although they had 6 attorneys, Lowell Lundy, who's a Kentucky attorney, was representing both defendants in the plea negotiations. And we talked about different potential pleas. And when we had a tentative agreement reached, we advised Judge Allred that we were in plea negotiations, that we had a tentative agreement reached. And he indicated that what we were talking about was not satisfactory, and he wanted more of the bond money that was put up by the doctors to be left in Harlan County in terms of some forfeiture or donation or something of that nature.
And if the plea agreement was approved and entered in open court on January 11th,
yes, sir.
When did this discussion with Judge Allred that you've just outlined for us take place?
I think there was probably more than one contact with Judge Allred, but it would have been between October, November, December of that year, preceding the January 10th plea.
And during the course of these discussions about the plea with Judge Allred, did he ever indicate to you that he would dismiss the case for lack of jurisdiction if all of the bond money was not taken from the defendants?
Yes, he did. Sheriff Lipford and I had met with Lowell Lundy in my office, and we had reached a plea agreement which called for, I think it was $600,000 of the money. Originally there was $1.4 million put up in bond. At one point that was reduced to $1.2 million, and $600,000 was to be forfeited or left there in some way. while Mr. Lundy was there, I called the judge and advised him that we were reaching this agreement. And after we completed that conversation, Mr. Lundy left, and I was still talking with Sheriff Lipford, and Judge Allred came to my office, which is very unusual. And he came in, and he was very emphatic and said that he wouldn't approve a plea that left where they took any of the money back, and that if we presented something else, he would dismiss the case for lack of jurisdiction.
How did that make you feel as Commonwealth Attorney?
Well,
These feelings are irrelevant to judicial conduct, aren't they?
I'm sorry?
Is that one of the elements is his feelings?
I can rephrase.
Rephrase it.
How did you react when Judge Allred made that statement in terms of the action you had to take as Commonwealth Attorney?
I said, well, we'll have to go back and start negotiating again. Now, actually, I did not think that Judge Allred would follow through on that as far as dismissing the case. I thought he was saying that because he was worked up and angry or agitated. And but I knew that we would have to come up with more money to be left there in order to do that. And so I had to recontact Mr. Lundy, and we had to work on it a little bit.
And did that ultimately lead to an agreement between the Commonwealth and defendants, the doctors, yes, whereby there was a reduction in the bond and the forfeiture amount was reduced to $500,000, $250,000 per doctor that would be divided according to the forfeiture statute,
right,
and then a $500,000 donation made to the Harlan Fiscal Court.
Right. And let me explain how that came about. Judge Allred had indicated earlier that he wanted money from that bond to be used for the Bluegrass Challenge Academy, which is a kind of a halfway house type of program for troubled youth, for that to be built in Harlan County, and to expand the drug court program. Now, asset forfeiture is something that happens in drug trafficking cases where there are proceeds of drug trafficking that the defendants have, and it's basically forfeited to the Commonwealth. Now, as far as doing it for these purposes, okay, we had talked about that, and when we finally reached the agreement where $1 million was to be left in Harlan County, we advised Judge Allred. At that point, he wanted to not have it for those purposes, but to use it to construct a water park. And the way that we were going to accomplish the money that was going to go to things other than pure asset forfeiture was, the agreement was for an asset forfeiture of $1 million. And the defense counsel had wanted to make it as a donation to the county instead of asset forfeiture because it would be tax deductible to them. But I could find no statutory authority for something like that, for requiring them to make a donation. I couldn't find anything that said you could do that, and advise them of that. Then the idea was brought up that they would make a motion to reduce the $1 million in asset forfeiture by $500,000 in order to make a donation to the county to be used to alleviate drug abuse in Harlan County. And I would have no objection to that, and so that would work that way. So they made the motion to do that with the money to be subject to the approval, the use of the money to be subject to the approval of Judge Allred. And I had suggested that, actually, because since he changed from the original Bluegrass Academy and expanding drug court over to this water park, I thought there might be another change. And so we shouldn't specify. And I proposed that general language, and I advised the judge of that. And then that was in the motion, it was in the order, and I mentioned it in open court. And that's what happened.
And so before the hearing on January 11th, when you talk about open court, before that hearing, if I understand what you're telling me correctly, Judge Allred was involved in trying to exert some control over how these funds were going to be expended?
Yes.
And Originally, he suggested that they be used for the Bluegrass Challenge Academy and then to expand the drug court.
Yes.
But at some point, he changed and said he wanted the money to be used for a water park.
Correct.
Let me show you a couple of exhibits. Let me show you what we've marked as exhibits 1 and 3 in this proceeding. Mr. Johnson, take a second and look at those. 1 and 3, Judge, is what I'm showing.
Right.
Okay, number 1 is the motion that was filed to reduce the bond amount to $500,000, with
correct.
the remaining $500,000 to be donated to the Harlan Fiscal Court to alleviate drug abuse in
Correct.
Harlan County, subject to the approval of the Harlan Circuit Court, correct?
Right.
And then the order that was entered January 11th is consistent in providing, and basically sustaining the motion and setting forth those terms. Is that correct?
Yes.
Were these terms discussed with Judge Allred? The terms
Yes.
of this motion and the terms of this order?
Yes.
And tell me what you recall about happening in open court when this was discussed and the motion was heard.
When the motion was heard, well, the judge, we talked about it with the judge before motion hour. And then when the motion was heard, I explained what the plea agreement was. I explained that I had no objection to, I said I had no objection to the motion. The defense had filed the motion, and I included that portion in my explanation of the plea and the fact that the $500,000 was subject, the use of it was subject to the approval of the judge.
And those terms were read in open court?
Yes.
And Judge Allred was there presiding at the hearing, correct?
That's correct.
And he approved this agreement?
Yes, he did.
And then did you receive a copy of the order that he signed setting forth those terms?
Yes, I did.
Yeah. Let me show you what was marked as exhibit number 6. This is the order entered on March 11th, 2010 in the Commonwealth versus Dr. V and Dr. Lavani case.
Yes,
Have you seen that order before?
I have, yes.
Who prepared that? To your knowledge.
I do not know. I didn't.
That order indicates that the language that's in the January 11th order was put in inadvertently. Do you agree with that?
No.
Why not?
The judge knew about it. Before the motion was even filed, he knew about it. We discussed it. He had told me what he was going to use it for, and which was the water park. And he had told me that he had an appointment to go talk to a gentleman who put in a water park. And he did that very close to the date of the plea, is what he told me, that he went and talked to someone who just put a water park in Barberville.
And in that same order entered March 11th, we marked as an exhibit that's before you, it also says it was neither solicited nor approved by this judge. Is that accurate?
No.
Why not?
Well, he solicited the money, and he was stating what it was to be used for, and he definitely approved it when he signed the order in the first place.
Did you have concerns? The order said that it was the funds were to be donated to the Harlan Fiscal Court to alleviate drug abuse in Harlan County.
Correct.
Among other concerns, were you concerned that a water park wouldn't fall within the parameters of that?
I was concerned about that, and I went to the county attorney and told him of my concern. I said, I think that if this is used for a water park, the doctors may sue to get the money back because it's not being used to alleviate drug abuse. That was my opinion. I just didn't think it was closely related enough. I saw it as a risk.
As Commonwealth Attorney, 1 second, please. Just need to get to my other set of papers here before I move on. As Commonwealth Attorney, at some point, did you become aware of an investigation that was being conducted by the Sheriff's Office in Harlan County involving Judge Executive Grisham?
I did.
Tell us when you learned of it and how you learned of it and what you came to learn.
I would say it was in the fall of, it'd be the fall of 2009 sometime. I'm not exactly sure what date, but the sheriff came to me and said that they had an informant who had told them that she could buy drugs from Joe Grisham in his office, and that also she could buy drugs from other well-known people in the county who she said were together in selling drugs and that sort of thing. And the sheriff had wired her with a video device that would record what happened and sent her in, and she came out with a pill. Now, she was searched before she went in, and she came out with a pill. On the video, though, you did not see that pill change hands. You would have to take what she said as truth in order to deem that there was actually a drug handed over by Judge Grisham. And the problem with that is she's a drug addict, and she'd been through drug court. She was facing drug trafficking charges at the time, and that's not good enough. That's why we wire them, is so that we do not have to rely on the informant's credibility itself. We have it right there. Well, after I watched it, I told the sheriff, well, this is something, but it's not enough. And also that I did not think that he asked me, should I investigate it or should I drop it? And I said, you have to investigate it, but I don't think you should be doing it. And I said, you need to go to the Attorney General's office and have their public integrity section oversee this investigation. And so that's what happened.
Then what was the next step in the investigation that you became aware of?
They, after they had done 2 more tapes where they sent her in and so forth, the Attorney General's office deemed that there was not evidence of a drug transaction and that the informant was not credible. Mm-hmm. And so they were dropping the investigation. Now, at one point I talked to Judge Allred about that in his office. I think he had asked about it, about what was going to happen with that. And I said, well, I think the case needs to go to the grand jury, even though we know it will be a no true bill, which means no indictment. Because when you have an investigation of a public official, the public needs to see that it's not being swept under the rug and that the evidence is presented to a grand jury. And they make the decision that there's not enough evidence for an indictment. So he was in agreement with that. And then later he suggested that we use a special grand jury. In other words, or actually what he was talking about was a grand jury from another county so that they wouldn't have the taint of local politics involved in that jury's decision, that grand jury's decision. And I thought that sounded just fine, sounded okay, and said that that would be good to do that. And for that matter, I don't know if he suggested it or I did. I said maybe we should even have a special prosecutor. And the reason for this is that Joe Grisham and I were both elected officials in Harlan County. And, I wanted to make sure there was no taint of politics involved in what happened with the grand jury. So I got a phone call, I think it was on the 22nd or the 23rd, where the judge said he had entered an order to appoint a special grand jury because he had talked to another judge who knew about these things, who said that we couldn't just get a grand jury from another county, that first we would have to try to impanel a grand jury in Harlan County and see if they had problems with, prejudice one way or another against the accused. And so we'd have to try that. So he was ordering that a grand jury be summoned, 50 people, and see if we could get a jury. And
Before you go on, can I just kind of interrupt for 1 second?
Okay.
Mr. Johnson, I apologize, but I want to try and get the timing down, because I think that's important here in terms of putting this all in order.
Right.
The conversation you had the conversation with Sheriff Lippert, in which he briefed you on the investigation, told you what he had, showed you the tape.
Right.
You suggested it go to the Attorney General to have them investigate. And at some point, you received notice, is this now in 2010, you received notice that the Attorney General did not believe there was evidence to support the allegations?
I believe it was in 2010.
And then you go and you discuss the matter with Judge Allred. Do I have the sequence down?
Yeah, I don't think I went over to discuss it with Judge Allred. I think I was over there for something else, and it came up.
Did he bring it up?
I believe he did.
Did he know about the investigation?
He did.
Did he know detail, from what you could tell from the conversation, did he know details about the investigation?
Yes.
What did he say?
Well, he just seemed completely familiar with the case. He didn't really give me specific details of the investigation. He knew there were videotapes. He said something about that. He knew who the informant was. I advised him about the Attorney General's office being brought in to oversee it and what their conclusion was. And I also advised him that there would be a no true bill returned because there just wasn't a case there against Judge Grisham.
And that was based on the lack of video evidence, Ms. Hensley's lack of credibility,
Correct.
and the Attorney General's investigation into the matter.
Correct.
But was there a discussion then before April 22nd with Judge Allred? There was this discussion about convening a special grand jury.
Well, right, or a grand jury from another county, yes, from Bell
And
County.
was there also a discussion with Judge Allred, because this investigation had been pending, and with the election that was coming up in a few weeks, that this matter should be presented before the election?
Well, at that time, although there were little rumors circulating about it, people really didn't know about it. It wasn't common knowledge that there was this investigation of Joe Grisham or anything of that nature. You know, close to an election, there are all sorts of rumors that fly around, and I didn't think this one was being given much weight, much buzz. So I really wasn't in that big a hurry to present it at that time.
Well, what was your thought process in terms of when it should be presented and how it should be presented?
I really didn't have a strong feeling at that point that it needed to be done before the primary.
At that point in time?
At that point. At that point.
At some point later, you felt it needed to be presented before the primary. Is that correct?
That's correct.
All right.
There was a change in circumstances.
Okay, and what was that change of circumstances, Mr. Johnson?
Okay. The order that the judge entered for a special grand jury named County Judge Executive Joe Grisham and his office. In other words, it specified that this was from drug trafficking in his office. And that caused a big fuss. And the way this happened was on April 22nd was when the order was entered. On April 29th is when I heard from Judge Allred about an order being entered. Then that Saturday night, emails were sent to media saying a special grand jury has been ordered to investigate drug trafficking in the office of County Judge Executive Joe Grisham.
What date did I supposed to inform you on?
April 22nd was the special grand jury order date. What date did you receive the call?
It was either late that day or the next day. Now, I know he did call me on Friday about that
23rd?
order, the 23rd.
I want to be clear about this.
Thank you, Judge.
Right. He did call me on Friday. Then on Saturday, that was disseminated. And on Monday morning when I came into the office, I received phone calls from an AP reporter and another reporter from it may have been WYMT, the TV news. I'm not sure who it was, but there was another one who called me about it. At that point, I had the order, but I hadn't seen it yet. It was in my office, but I hadn't seen it yet. So when I got these calls, I opened it up and looked at it and saw what they were talking about.
And what was your reaction when you read the language of that order?
And
I'll show it to you.
Right.
Exhibit number 11.
Could I have some water? I'm just, do you have any available? Please?
Go make you some.
Okay, should I go ahead or wait?
Continue on.
We can continue on if you're,
Okay.
as long as you can speak.
Sure, I can. Okay, there were some things that were wrong in the order. For example, that it was to deal with an ongoing and lengthy investigation, which could not be handled in the term of the regular grand jury. At this point, the investigation was over with. There was no more investigation going on. Okay, the order actually refers to the Harlan County Judge Executive and his office, but does not name that it's Joe Grisham, but everyone knows who it was. And says again that it's an ongoing investigation. I thought that my reaction was that I thought that the part about it being an ongoing investigation was incorrect, and also that naming the Harlan County Judge Executive and his office was not necessary to do this. All that was necessary was to direct that 50 jurors be come in to see if they could be impaneled for a special grand jury. I did not like what this was doing as far as Mr. Grisham's impact, the impact this would have on his candidacy for re-election with the primary coming up May 18th. And the special grand jury was to come in May 25th, which would be a week after the primary election. And of course, there's a lot of press coverage about the order, and thank you very much.
So you got this order, and you saw immediately there were some things in there that you identified for us that you thought were incorrect.
Correct.
And you were troubled by the fact that it specifically designated that it was an investigation into selling of drugs by the Harlan County Judge Executive out of his office.
Correct.
And you knew that primary election was coming up in a week or two, and this would have an impact on that election probably.
Correct.
And so did you draw any conclusions as to any motives that may have been behind the entry of this order?
Yes, I thought it was political, and I thought the dissemination of it was political. Sending it out like that to the media, I thought was a political act, and an attempt to use the criminal justice system for political purposes.
Mr. Johnson, did you release that order to the media on April 22nd, 23rd, 24th, or 25th?
No.
When did you first read it?
The 26th, Monday.
On April 26th, did you provide a copy of it to a reporter?
I did.
Tell us the circumstances under which you did that and why.
Okay, I had received these calls from out-of-town news outlets, and I called our local newspaper to find out what they knew about it. And I was calling for Debbie Caldwell, who was the news editor at that time. I've known her for many years. I've known the people out there for many years. And she was not there due to illness of her daughter and so forth. So I was put in contact with the reporter at that time, Nola Sizemore. And she came to my office. She hadn't heard anything about it. Now, I don't know if the email was sent to Debbie Caldwell, who was out of the office because of her daughter's illness, or if the local paper was not sent one, or what. But Nola came to my office and to talk about it, and she asked me to give her a copy of the order. And it's a public record. It wasn't sealed. I thought, you know, she can get that. She's allowed to get that. So I gave her a copy of it. Also, the people who had called me, the reporters, had told me exactly what it said. You know, that it was to investigate illegal drug trafficking in his office. My impression was they had been sent the actual order. But I later found out, after I saw one of the emails, that it wasn't the actual order. It was just a recitation of what was in the order. But anyway, I gave her a copy of it, and then I started thinking about it, and I said, I'll tell you what, let me have that back and just go ahead and get one from the courthouse. And she said, well, let me keep this, and if I can get one from Judge Allred, then I'll just tear yours up. And I said, okay, you know, okay. So later she told me that that's what had happened. And then later I I heard that that's not what happened, that she in fact kept mine and didn't get one somewhere else. But that's how I happened to give her one. And that was on Monday after the email had gone out to the media on Saturday night. The reason that I called out there is that whenever I get calls about a case from out-of-town media, I usually call the Enterprise because I do not want to give statements or press conference to the out-of-town media and cut out our local media. In other words, if I'm going to talk to somebody about it, I want them to be included.
Let me show you what we marked as Exhibit 13. This is an email strand. It's been exchanged in discovery in this case. I believe it starts on April 25th.
Right. This is the one I saw.
All right.
But I didn't see this until later. I saw this when it was given to me by Judge Joe Grisham, County Judge Executive Joe Grisham gave me this.
So Judge Grisham gave you a copy of that?
Correct. Right.
Of Exhibit 13. Do you recall when Judge Grisham gave you that?
No, I don't.
All right. But that seems to confirm, if the dates are accurate, that there was media were looking at this order that was entered in the circuit clerk's office on April 22nd, correct?
Right.
And
I'm going to object. I think we leave quite a bit, Mr. Chairman, but I'm going to object to way too much leaving this case.
I agree with you, Judge.
I'll do a little bit better. I'm trying to be a little too efficient, maybe, in moving this along.
Let Mr. Johnson do the testifying.
Did you have any advance notice that Judge Allred was going to enter the April 22nd order?
Not that order. I knew that he was going to do something to try to get a jury from Bell County, a grand jury from Bell County. And the first, when he called me, he said that first he had to try to impanel one in Harlan County. And I knew about that, and I agreed to that. I didn't have any problem with that.
Tell us in a little more detail, because I don't want to skip this. What happened during the conversation when he called you? I think you said either that night, the 22nd, or the next morning, the 23rd. What do you recall about that conversation?
I recalled that he said that he had entered an order to try to impanel a special grand jury because he had talked to another judge who knew more about it, who said that he needed to do that before we could go out of county to get an out-of-county grand jury.
Mm-hmm. All right.
And I had no objection to that.
What happened after this grand jury order was entered
Okay.
in the circuit clerk's office, and you told us about what happened over the weekend with the media,
Right.
and what happened with Nola Sizemore on that Monday or so.
Right.
Tell us what happened next.
There were newspaper articles, and there was a lot of talk in town and in the county about this investigation. And Judge Grisham called me and wanted to talk to me. And I had been intending to call him because I wanted to talk to him. So I went over to his office, and he said, "It's not true, I didn't do this," and so forth. And I said, "Well, that's what the investigation shows, is that it didn't happen." And he offered to take a polygraph examination, a lie detector. So I said, "Well, if you take a polygraph and pass it, I will present this next on Monday, the Monday that was coming up, to the grand jury, to our sitting grand jury that meets every Monday, because I felt like this was unjust to him to have that shadow hanging over his name until after the primary, when everybody knew that it was going to be a no true bill, that there was nothing to that." So he did take the polygraph, he did pass it, and I did present it to the grand jury.
All right. Tell us about what happened on May the 3rd, which is my understanding, the date that you presented it to the grand jury.
That is the date that we presented it to the grand jury. And I had the witnesses there to testify. And we'd started the presentation, or we at least had started the session of the grand jury, when one of the courtroom bailiffs came and knocked on the door and came in and said that Judge Allred wanted to see me. So I went back to his office, and before I got to his office, he met me in the hallway, and he was shouting. He said, "What are you doing?" I said, "I'm presenting the Joe Grisham case to the grand jury." And again, he shouted, "What are you doing?" And I said, presenting the Joe Grisham case to the grand jury. And he started shouting at me, said to get out, to never come back there where his office is again, that he was going to have me investigated by the FBI, and some things like that. He was really angry and wild. So I left because he was shouting, get out, get out. So I left that area, and I went back to the grand jury and proceeded to present the case to the grand jury.
At any point, did you give Judge Allred or attempt to give Judge Allred any notice as to what you were going to do in terms of presenting this matter to the regular grand jury?
I had sent him an email the night before, which I think he probably did not receive. And I had tried going into his office beforehand, but he wasn't available at the time. So I just went on to the grand jury, and I was going to present it.
So you made some efforts to try and contact him?
Yes.
Then what happened next?
Then, as I was presenting the grand jury, the case to the grand jury, a bailiff came in with an order that we were to preserve the evidence, not to destroy the evidence. And I was also advised that my access card to the secure areas in the courthouse had been invalidated, so I could no longer get into those areas. I could not, for example, pull into the fenced parking area behind the courthouse in order to bring in my files for motion hour. And I might have 3 or 4 banker's boxes full of files that I use a dolly to go in, and I could go in the back door, come up the elevator, and take them straight into the courtroom. So that was stopped. And let's see, also I was to be escorted out at the end of the day, and I don't remember right off the top of my head now if there was anything else besides all of that. But there were signs that he was really displeased with this.
Were you provided with any information as to why your secure access was being revoked and you had to be escorted out of the courthouse?
As far as being escorted out, I have been told that that was because since my card had been invalidated, they would have to take me out to my car and let me out. And that's correct. That's correct. But at the time, that didn't register. At the time, I just thought, well, I'm being escorted out by my car. So. But for the rest of it, no, I've not been given an explanation for that.
Did you, at the time, given
I've not been given an explanation for that.
And at that time, given what had happened that day, did you form an opinion as to why this was being done?
Sure. It was obvious from how angry he was about me presenting the case to the grand jury. I knew there was a connection in that.
Were you aware at the time as to who were the opponents that Judge Grisham had in the primary election in May of 2010?
One of them was Denny Pace, who is a second cousin to Judge Allred.
Let me show you what marked as Exhibit 15. I think you may have referenced that earlier. You recognize that document?
Yes.
All right. Tell us how you came to receive it and what you did when you read it.
This is the order that the bailiff brought to me. I think it was the bailiff. It may have been a city police officer. But anyway, a law enforcement officer of some sort brought this into me in grand jury. And that's the one that says that the evidence was to be preserved and that there was a special grand jury being convened, and states that the Commonwealth Attorney and the Harlan County Sheriff, having unilaterally decided to present the case to the Harlan County Grand Jury, that the evidence needs to be preserved in order to be presented to the special grand jury convening the last week of May.
As Commonwealth Attorney, did you see a need for that order?
No, we were going to preserve the evidence anyway. I mean, we would always do that. Also, saying that about the Commonwealth Attorney unilaterally presenting it to the grand jury, that's within my discretion. It's one of the things I do as a Commonwealth Attorney is present cases to the grand jury at my discretion. And it's true that I had agreed to the special grand jury, but that changed when all this hit the public like that, and when I felt like there was something unfair going on, that changed everything. And that's why I decided to go ahead and present it to the grand jury. I could not wait for the special grand jury because it wasn't even coming in until the 25th. And that would be too late. The damage would be done.
When you spoke with Judge Grisham during the week of April 26th, and he told you that he didn't do it, did he express any statements about how or why this was released?
Yes, he did. And I didn't. He was talking about an affidavit that he had given to James Howard, and about being called into the judge's office concerning that affidavit, or that the affidavit was about being called into Judge Allred's office concerning a lease given to James Howard of some property.
I'm sorry.
Let's find out what someone else told him, that Bishop told him.
Can't do that.
But
Without, if you can answer the question without giving hearsay,
Right. Okay.
Mr. Johnson, go ahead. If not, I'll move on.
yes, at the time that I presented the case to the grand jury, I was of the opinion that it was related to the election and Denny Pace's chances because of his connection to the judge. Later, I found that there was another reason, because I obtained a copy of an affidavit given by Joe Grisham in the case of James Howard, and I watched the courtroom proceedings on that to see the context for that affidavit. And it was where James Howard was in a case, a civil case, and had asked Judge Allred to recuse, and the judge refused. At that point, his attorney, Rodney Buttermore, gave the judge the affidavit from Joe Grisham, which detailed being called into Judge Allred's office and being told that the judge wanted him to rescind a lease that had been given to James Howard by the county because he wanted the property to be used for a different purpose. And as soon as the judge saw that, his demeanor changed, and he recused later from that case.
And did you draw any conclusions about the date that affidavit was presented?
It was April 22nd, and it was before the order.
The special grand jury order.
It was before the special grand jury order. You know, the affidavit given by Joe Grisham was presented to the judge. Then later that day, he entered the special investigation order, the special grand jury order.
One second, please, Mr. Chairman, to confer with counsel.
You may.
Thank you, Mr. Johnson. So the questions I have, at the moment I'll pass to Judge Allred for cross-examination.
Judge Allred, you may ask.
Mr. Johnson, I'm going to run along with this, and I'm going to ask you a few questions. And if you don't understand my question, please let me know and I'll ask a better question. If you can't hear me, tell me and I'll speak up. If you answer yes or no, and not or maybe, please. You just testified that, correct me if I'm wrong, you just testified that there was no reason for there to be a hurry to get this to the grand jury because the investigation was over. When did the investigation
No, that's not
end?
what I testified. You said to correct you. What I said was I didn't think there was any need to be in a hurry to get it to the grand jury because it wasn't really public knowledge. There were some light rumors going around that I don't think were generally believed or given much weight. And so I didn't see it as urgent to get it to the grand jury at that time.
Didn't you testify just a few minutes ago that the investigation was over
I
once
did.
the AG's office did their thing?
The investigation was completed.
Okay, and what date would that have been?
I don't know exactly.
After the AG's office had sent you a letter?
I've turned the letter over, and if someone has that available, we can
What was
make it.
what was the date of that letter, do you recall?
I do not recall.
Well, was the investigation over before I convened the special grand jury?
Yes,
That's your testimony.
it is.
And what are you basing that on, Mr. Johnson?
Because I had already told you what the findings of the Attorney General's office was, and there was going to be a no true bill. At that point, I already knew that the investigation was over with.
So the sheriff's office didn't continue to investigate after the special grand jury was convened?
Not that I know of.
Did you review the police reports of the investigating officer in regard to this case before presenting the matter to the grand jury?
I did.
But I'm going to mark this.
Why don't we use letters, Judge, for you? Respondents A.
Respondent A? Thank you. That'll keep the exhibits clear. I appreciate you helping me with that. Forgive my handwriting because it's not the best. My mother has always been on me about my handwriting, so I've tried to do better. May I approach the witness?
Certainly.
Does this appear to be the police officer investigative report? Did you review prior to presenting the matter to the Harlan County grand jury, Mr. Johnson?
Just a moment. Let me take a look at
Take
it.
your time, sir.
Yes.
Okay. If you would, turn to the page that I have marked with the yellow tag. Would you look at the bottom of that page and read the second to last paragraph, the short one?
Right. On 4/27/2010, IVA 09038 Melissa Hensley was transported to the Kentucky State Police Crime Lab Polygraph Office in London, Kentucky by Detective Jason Snelling, and I guess that means informant, Ms. Hensley refused to take the polygraph examination by stating she had a medical condition.
What was the last sentence on that page?
It says the case is still under further investigation by the Harlan County Sheriff's Office until handed over to the Harlan County Grand Jury for final disposition.
Moved into status, Exhibit A. Counsel Exhibit A. Okay. So, you were wrong about that. It was still under investigation, right?
I don't think so, and I'll tell you why.
Okay.
Now, when Joe offered to take a polygraph, when Joe Grisham offered to take a polygraph,
Non-responsive, Your Honor. Would you ask it?
He could answer the question. You asked him a question, he said he didn't think so, and now he's explaining.
yeah, and you asked why, so I'm explaining why. So when Joe Grisham offered to take the polygraph, I thought it would be fair to have the informant take one too. So we arranged a polygraph for her also. I don't think that was part of the original investigation, though, because the original investigation had already determined that there was no evidence to indict Mr. Grisham on, and the letter from the Attorney General saying so was back in, let's see now, or rather the report from the Attorney General saying so was back, I think, in March, or it was certainly before the date of the special grand jury order. And,
Sure.
and it may say that the case is open because, you know, a case can be investigated up until trial, but I don't think any further investigation was done. The case was over with. It was not a lengthy ongoing investigation that would require a special grand jury, which is what the order says. That just wasn't true.
That's the Harlan County Sheriff's investigative report, correct, sir?
It is, yes.
And that investigative report says on the page that you just read, the investigation is still ongoing until the matter is handed to the Harlan County Grand Jury.
Right.
Correct?
It says that, yes.
Yeah.
But no other investigation was done, and it was completed. I mean, it may say that, but the investigation was finished.
Who was the chief case officer for this investigation?
It says, I'm not really sure.
Silas Whitehead, the investigating officer?
He's one of them. But,
So you
know,
disagree with the report that there was no ongoing investigation?
I agree that, yes, I think there was no ongoing investigation at that time. I don't think any further investigation was done other than the polygraph examination, which she refused. I mean, you know, you could say, too, that the polygraph by Joe Grisham was part of the investigation, but it really was more to settle in my own mind that this was the right thing to do, to take it to the grand jury early.
Now, let's talk about this.
Because it's not admissible anyway.
I don't want it. It's not admissible anyway. Okay.
No, polygraphs are not
Did
admissible.
you let the grand jury hear about the polygraph?
Yes. Now, the grand jury is not, the rules of evidence do not apply to grand jury, as you very well know. And so the grand jury is allowed to hear about polygraph
Did you
tests.
tell the grand jury that the confidential informant refused to take a polygraph?
That was gone into, yes.
Now, you
I
said...
didn't tell him that. There was actually a video of that, I believe, or there was some indication that doesn't come from me about her not taking the polygraph.
Now, you said the reason that you skipped the special grand jury that you agreed with by your own admission was that you didn't think it was fair to Joe Grisham for someone to use, basically, the grand jury to be used for a political purpose. To get this
Correct.
over with. Is that correct?
That is right. I think that when the email was sent to the media, it was to create the impression that Joe Grisham was selling drugs in his office.
You might have the exhibit of the email since Mr. Johnson.
It's
It's
Sure.
number 13, Judge.
You have that over there?
yeah, here it is.
Would you look on this email and see if it was sent according to, first of all, are you familiar with computers?
Well, a little bit.
You spend a lot of time on computers, you know.
Yeah, I do.
Okay. Now, are you able to tell on an email like that, can you look and see what the history is of where it was sent to?
Okay, yes, and it says Sunday rather than Saturday. I was mistaken about that.
That's right. And if you look at that email, if you look on it says, it usually starts out with who sent it out first. And on that email, wasn't it sent by somebody named Smith? What's his
Well,
name?
I don't know if it was sent by somebody named Smith or not. It has the name Smith on there, but with email, you can create a name that's not your name and send emails under that name. And, you know, David Smith.
You can use email to do things under disguised names, correct?
Sure.
Have you ever done that? Have you ever logged on to a chat room other than guess or know something about the law?
Not on those names.
You ever logged on to know something about the law?
No,
Have you ever had anyone do that at your request?
no.
Go back to that email there, you see. Can you tell me what media outlets that email, according to the history on that email was sent to? What media persons was it sent to?
Well, I don't recognize all the names. There's Adam Yeomans. I don't know who that is. Andy Mead, Angela Bevan, Ashley Reynolds, Elizabeth Campbell, Charles Coker, Neil Middleton. Neil Middleton is the the director, producer, he's some executive over at WYMT, which is the TV station in Hazard, which is our local station. Peter Baniak, I don't know who that is. Roger Alford is the AP reporter, whose name I had forgotten. But it's Roger Alford. He lives in Eastern Kentucky also, and he's a stringer for AP. And he's one of them who received this.
Did any, according to that document, that exhibit, what's the number again, I'm sorry, 13, exhibit 13, was that email sent to the Harlan Daily Enterprise? According to that document?
No.
Now, you testified that you called the Harlan Daily Enterprise because you were getting the calls from all the other media outlets, correct?
Correct.
And you contacted the Harlan Daily Enterprise because you like to give the local folks the jump first, correct?
Well, I want them to be included.
Yes. And you testified when you called to ask for Debbie Caldwell.
Right.
She wasn't there, correct?
Correct.
Who put you on the phone? You know what put you in touch with Noah Sizemore?
No, I don't.
When Noah Sizemore got on the phone, is it your testimony today that she did not know about the email?
That is correct.
Did you ever tell Gene Weaver, the investigator for the Judicial Conduct Commission, in a statement that he took from you, that Noah Sizemore already knew about the special grand jury order before she came to your office?
I may have. And if I did, that's probably correct, because that would have been closer in time to when this all happened, because it was May of 2010.
So you changed your testimony here today. She did know about it.
Well, I don't know. Can you show me where I said that she did? That she knew?
You're telling Mr. Weaver.
I said I don't know. If you can show me, I'm not going to say that I've changed my testimony unless you can show me that I said something inconsistent.
Well, let me ask you a question.
Go right ahead.
Simple. When you talked to her on the telephone about this event, what did you tell her when you talked to her?
I don't recall the exact wording. Basically, I inquired whether she'd gotten an email about this order.
And what did she say?
I thought she said no.
Okay.
But either way, she came down to my office to ask about it and to see if she could get a copy of the order.
If she didn't know about it, why would she come to your office to ask about
Well, I
it?
told her about it.
You told her about it when you called her at the
Yeah.
Enterprise?
Yeah.
Okay. And you gave her a copy of this special grand jury order, correct?
Right.
That was on Monday before the story broke in all the newspapers, correct?
It was before the newspapers published it, but it was after this email had been sent to these media outlets.
And you talked about all the media coverage that went on in regard to this special grand jury. Weren't you the only one giving interviews about this issue?
I don't think I gave an interview about it, really.
You didn't give a statement.
I gave a long one after I presented the case to the grand jury.
When it was published in Harlan Daily Enterprise on Tuesday, the Tuesday after you gave Noel Sizemore the order on a Monday night, is it your testimony here today that you did not give her an interview that she published in the paper?
I do not know. I don't know what I told her. Or the other media.
I'm sorry.
I said I don't know what I told her or the other media.
There is an article that has quotes in it for you by Noel Sizemore. You wouldn't disagree with that?
Let me see the article and then I can tell.
There's a lot of articles in Harlan. Last I read. April 27, 2010, Harlan Daily Enterprise.
I'm sorry, what's the date, Judge?
April 27, 2010, Harlan Daily Enterprise.
Thank you.
Did I see that?
Now, approach any of these exhibits, please, if you don't care. I'm marking this for identification purposes at the top of the newspaper. The respondent's exhibit B.
B.
Declaration.
And yes, you may approach.
Thank you very much. Please feel free.
All right, thank you.
You're very welcome. As you can see, it doesn't take long to read our paper. Most of the obituaries were.
Oh, okay. I see what you're talking about. I did give a statement. Let me tell you, I remember this now. Let me read it to you. My statement was, at this point, People should remember the fact of the matter is, going to the grand jury for an investigation does not mean that there will be an indictment or that there won't be an indictment. All it means is an investigation has been requested and a grand jury will make a determination to see if there's enough evidence to charge someone or not. Johnson said individuals are presumed innocent until they are not only indicted but convicted by the court or a trial jury. Then a direct quote from me. The grand jury process has a lower standard of proof, said Johnson. A grand jury finds only probable cause to determine whether someone should be charged to stand trial. The trial jury is the ultimate arbiter of guilt or innocence. At this stage, there has been no indictment, and the matter has not been heard by a grand jury. It has not been investigated by a grand jury, and people should keep this in mind.
Does that article mention any discussion of the special grand jury order itself? Does it use or have any discussion about the words in it, how it was written?
No. I was not commenting specifically about, I was not giving the specifics of this case. What I was doing, if you'll notice, in everything that I said there, I was giving a general explanation of the role of the grand jury and what it does and what their standard of proof is and whether or not it shows guilt or innocence. And I was trying to, at that point, I was trying to ameliorate the effect of having this publicized. I knew there were going to be articles about it. And I wanted to, let people know at that time what it meant.
So you were trying to ameliorate,
Correct.
Which is a big word, for trying to soften the blow of all this, by calling a newspaper reporter, having her come to your office, giving her a copy of the special grand jury order, and letting her do a front-page story in the Harlan Daily Enterprise about it. That's how you ameliorate.
Well, the cat was already out of the bag then. I mean, whoever emailed it to the media is the one who publicized it, and the media was calling me about it. They were already doing stories. And so the question was, should I give a statement or not? Since they were already going to do the stories anyway, and I knew that, I was giving the statement just saying, this is what the grand jury does, and this is what it means. It doesn't mean that somebody's guilty. That's all. And I didn't want to go into the specifics of the case. I didn't want to say, there's been an investigation that shows there was no crime committed at that point. I just wanted to try to soften whatever the story was going to be about it. And you'll notice that the facts about the special order and the special grand jury is before they start saying anything about any statement that I made.
If you would, please, since you bring that up, turn to the front page, leave it on the front page and read the facts about the special grand jury. What does it say?
It says, a general order was issued on Thursday by Harlan Circuit Court Judge Russell Allred directing a special grand jury be seated to investigate alleged drug trafficking by Harlan County Judge Executive Joe Grisham from the Judge Executive's office. The order was issued as a result of an ongoing investigation by the Harlan County Sheriff's Office. That information comes from the order. Allred ordered a special grand jury be seated because the investigation could not be handled during the term of the regular grand jury. The Harlan Circuit Court clerk was ordered by Allred to send out 50 juror summons for a jury pool for the special grand jury investigation. And then there are my statements about what it means.
Is there anything missing from that report? It's got everything in the order except for one thing.
Are you going to? I did not notice anything like that.
What exhibit number was the special grand jury order that you all had?
It's, Judge, I don't recall a number, but I did ask him about it. It's on the
table. Okay.
It's 11, Judge.
11. If you would, find us exhibit 11.
Mm-hmm.
Now, you just read the newspaper article. Read the special grand jury order.
Okay. It is ordered and directed after consulting with the Commonwealth Attorney for the 26th.
Oh, stop right there. Was the first line of the special grand jury order reported in that article that broke the story?
No.
Isn't it true, Mr. Johnson, that the reason you gave this special grand jury order to Nola Sizemore was because you were mad that the special grand jury order specifically said that the Commonwealth Attorney's Office had been consulted about this before it was done?
No. I think that's technically correct. I think you had consulted with me about it.
Why is it not in the newspaper article?
Pardon me?
Why is that not in the newspaper article?
I did not write that article. I don't know. But
I would say the answer he knows.
He can answer if he knows.
I don't know why that was left out. But I think that's correct. I think you had consulted with me about it.
Isn't it true?
I already explained the circumstances of that and why my views on that changed.
Isn't it true that you told Nola Sizemore how to write this newspaper article?
That is absolutely not true.
Did you tell her to leave out the first line of the order
No, I
that said
did
after
not.
consulting the Commonwealth Attorney's Office?
I did not. As a matter of fact, when I gave, after presenting the case to the grand jury, the no true bill, when I had the press conference to explain why I had presented this to the grand jury in that way, in that press conference, I stated pretty much what I've stated here today, that I had agreed to a special grand jury, that I had agreed to these things, and that all of that changed when that email went out to the media.
Where's that in that article there, that you agreed to the special grand jury?
It's not in there. But I don't know if they thought that was too boring to put in or what, but I don't care if it'd be in there. I had announced that to the media.
Not on this day.
Not on that. Well, it was in the order. I don't know why they left it out.
So your testimony is that you did not tell Ms. Noah Sizemore to leave that first line of the order out?
No, I did not.
Look at Mr. Harlan Enterprise dated April 27, 2010, by way of opposing counsel. In the record, as a recognized,
Can I take just a minute, Mr.
You
Chairman,
take
to read it because we have.
take all the time, I apologize for that, take all the time you want.
Allergies, and yeah. Let me ask you something. Why would you think that I told her how to write that?
I've already testified this morning, Mr. Johnson.
Okay. All right. Let me add something to it. I'm not embarrassed about the fact that you consulted with me ahead of time about it.
We have no objection to the admission of the article as Judge Aldred's Exhibit D.
Thank you very much.
Thank you, it'll be admitted.
We did have a really good band playing that. Now, Mr. Johnson, your testimony here today deals with fairness to Joe Grisham, correct?
Correct.
And it wasn't fair for Joe Grisham to have to go through all this situation with a special grand jury pending on him. You knew there was really nothing there, correct?
I'm sorry, the last part of that?
There was a special grand jury pending on him, and you knew there was nothing there, correct? Wasn't
Right.
there? So, to be fair to Judge Grisham, you took it on yourself to skip the special grand jury that you'd agreed with because of an email sent by Mr. David Smith, correct?
Well, because of what happened after that email was sent, and the fact that I was called by the TV station and I was called by the AP reporter asking me about it and telling me what was in the email.
Couldn't you just simply say no comment?
You sure?
Why didn't you?
Because I thought it called for a comment. I thought it called for a comment about what grand jury investigation means. Because I didn't want him tarred with the brush that he's trafficking drugs in his office when he was not.
Are you aware that Judge Grisham is now going to testify on my behalf in this matter?
I am aware of that.
When did you first become aware of it?
I couldn't say. I don't know. Sometime, I really don't know.
Have you subpoenaed Joe Grisham to the grand jury for an investigation here recently?
I have.
When did you subpoena him?
I'm sorry?
When did you issue the subpoena for Joe Grisham to
A few
testify to the grand jury?
A few weeks ago. It's on an unrelated matter.
So there's another investigation of Joe Grisham?
No, he's not the target of the investigation. He's a witness. That's why he's subpoenaed. I wouldn't subpoena the target of an investigation.
Okay.
They have their Fifth Amendment rights to remain silent and not to testify.
Okay. And what grand jury request did you issue that subpoena?
I don't understand your question.
Usually, doesn't the foreman or foreperson of the grand jury request that you all issue subpoenas?
No.
You wanna hear from them?
No.
So they don't have a right to ask for people to be subpoenaed to come in?
Sure, no, that's not what I said. They do have a right to ask for someone to come in and talk and testify to them. But normally, the foreman of the grand jury is not the one who decides what subpoenas are issued because he's not familiar with the case and it hasn't been heard yet.
So you had the subpoena issued, what was the day again they had issued?
I don't know exactly. A few weeks ago, a couple of weeks ago.
Who served that subpoena?
I assume the sheriff's office. They serve all our subpoenas.
Okay. Is Harlan County Sheriff's Chaplains Corps suing the judge executive right now?
They are.
Didn't they have an injunction hearing set for Friday where you walked by some of the Chaplain Corps members and said, I'm proud of you guys?
I did not say that. I walked by them because I was in court that day on an unrelated matter. And they were sitting there in the audience session, and I don't think I said anything to them. I did not say I'm proud of you guys.
Isn't it true that you subpoenaed Judge Grisham because Bill Ball, the Chaplain's Corps, had contacted you about how they were being treated unfair and some of their stuff was missing from the Chaplain's Corps building in Colbert?
No, that's not correct.
Objection, relevancy.
Your Honor, I have a witness that's going to testify on my behalf. One time was a witness on behalf of the JCC's prosecution or Mr. Johnson. It's odd to me in regard to this matter that the judge executive, who's already been put through the ringer with the grand jury previously, is now subpoenaed again to come and testify on September 12th at another grand jury, and he's not been told anything. His testimony will reveal what it's about, why he's been subpoenaed to the grand jury. It just simply says, in reading the investigation. So it's my position, Your Honor, that this is relevant because this is an attempt, once again, by the Commonwealth Attorney's Office and the Sheriff's Office to use this grand jury to harass someone, to get him back in line to testify on their behalf or to change his testimony back. That's why I feel it's relevant, and Mr. Grisham will be here tomorrow to testify about that as well.
You can answer the question.
Sure. Here's why I subpoenaed Joe Grisham to the grand jury. He's made statements that he had evidence that members of the Chaplain Corps and the Sheriff's Office were improperly using the funds and the property of the Chaplain Corps that they received from, Christian Appalachian Project or something of that nature. They receive a lot of property and they distribute it to people in Harlan County. And he has stated publicly that there is an investigation going. Excuse me. Well, I haven't heard anything about that. And I wanted to know what evidence he had and, to get an investigation actually going the way that he says that there is. But I'm not investigating him. I want to know what he says, what he knows.
Don't you think it would be a good idea to talk to him about it before you issue a subpoena to go to the grand jury?
Well, no, because right now he's blaming me for the business that happened May of last year, apparently.
Do you think it would scare somebody to have the sheriff who's suing him serve him with a subpoena to a grand jury and have no idea what it's about?
Well, since he's being served with a subpoena, he knows that he's not the target.
How do you know that? He's not a lawyer.
Well, he has lawyers who work for him.
Who are they?
One is Fred Bustrow, the county attorney, who's the legal advisor to the fiscal court, including the judge executive, and I guess whoever's representing him in that the lawsuit. I don't know who's representing him, but he would have that lawyer.
So is it your testimony here today? You're subpoenaing him as a witness
Yes,
to do an investigation on the Chaplain's Corps.
that's correct, because he has made public statements, not only to the press, but to individuals. He's repeated it many times, that property has been taken and sold on eBay. And I want to know if someone's taking that property and selling it on eBay. It's part of my job to find out who's doing it and to prosecute them.
Okay. Well, that's...
Why does he have a problem with that? Do you know that he does?
We'll hear from him tomorrow.
Okay.
Well, then, that's pretty good. That's really good. Let me ask you this question, which you've taken on your own initiative to help Joe Grisham in his investigation or an investigation into the Chaplain's Corps missing properties.
That's not correct.
Okay,
there was an audit done by the state auditor's office, and they found that there were discrepancies in some of the record keeping on some of the property involving the Chaplain's Corps. And at the conclusion of the audit report, they said that this report is being forwarded to the proper authorities for investigation and other proceedings, or something along that line. And they list the people that it's being sent to. One of them is the county attorney, Fred Bustrow, whom I just told you about, and the other one was me. And I think there was an ethics board maybe that they sent it to also. But they sent that to those people for further action.
Okay, so you're initiating this investigation because the state auditor...
Well, I'm not initiating it, really. I think the state auditor's office report initiates it because they say we have these discrepancies and we're sending it to the other people to look into further.
Well, I agree with you, the state auditor. I think that's a good move. What about regard to James F. Howard? Did you get a letter from the state auditor's office about discrepancies in the audit of him eating himself a piece of property in Columbus County?
I did. I think I
Did you
did.
hear that case?
Not yet.
What do you mean not yet?
Well, you know what the words "not yet" mean, correct?
Well, didn't you give a statement to WYMT and newspaper outlets that said it sounded like a civil matter to you if you weren't going to
No,
pursue this?
I did not. I said that it could be a criminal matter, it could be a civil matter, or it could be a matter that only requires criticism.
Well, did you issue a subpoena for James Howard?
James Howard is not someone who says that he has evidence of crime.
Did you issue a subpoena for the auditor that did the audit?
No, but I have the report.
Did you take any steps whatsoever to further that investigation?
I have talked to the Attorney General's office about it.
And what did the AG's office tell you? Well, strike that. I withdraw the question.
Okay?
But now in Joe Grishop's case, you've already issued a subpoena for him, correct?
It's not Joe Grishop's case. I mean, he's the witness.
Did you issue a subpoena for Lakis Malanitis?
I did.
And he's a witness in the case too?
He may be.
So Lakis Malanitis has been subpoenaed to the grand jury. Joe Grishop's been subpoenaed to the grand jury. James Howard and the witnesses in his case that referred to you by the state auditor has not been subpoenaed to the grand jury.
That one was a separate audit, and when I received that, it had something along the same line. And I did go to the Attorney General's office and discuss this with them, again with the Public Integrity and so forth office.
You're telling us here today that they told you not to investigate that case, or what?
No, they didn't tell me not to investigate it, but they haven't told me whether they're going to or not.
Now, what's the date of that letter I handed you, marked as Respondent's Exhibit C?
April 11th,
Of 2011?
correct, 2011.
And how many months ago was that?
Well, May, June, July, August, 4.5.
Now, is this the same James Howard that you've been corresponding with and meeting with concerning the issue since April and May of 2010?
I have not met with him about you or corresponded with him about you, I don't believe.
Mr. Johnson, I'm going to ask you to think about that before you answer that question. I'm going to ask you that question again. Have you met with James Howard?
I have talked to him. I've talked to him, I know, but a couple of times about it. But as far as meeting with him, I don't know exactly what you mean. Like
You ever
a
have to sit down
formal
with
meeting?
BP with him?
I'm sorry, what?
You ever come to BP gas station, had lunch with him?
I may have. I have lunch over there. It's across from my office. I have lunch there frequently. He may have sat and talked to me about it.
Okay. You're the full-time Commonwealth Attorney of Harlan County, correct?
That is correct.
As full-time Commonwealth Attorney of Harlan County, are you allowed to do any civil practice whatsoever?
No.
Can you explain to me how you would know about the Potter versus Howard matter, which is a civil matter on the civil motion hour?
Sure.
How?
Joe Grishop gave me that affidavit and said that it had been submitted in the Potter versus Howard case.
When did he give you that affidavit?
It was shortly after. It was in May of last year.
May when? Do you know?
I don't know the exact date.
Well, since May of 2010,
See, when I first brought this up, he was trying to point me to the fact that that affidavit would be a motivation for you to issue that order, the special grand jury order. I didn't get it. I was thinking that it was all related to Denny Pace being related to you and you trying to put him into office for that.
but you're saying Joe Grishop was the one behind all this, to make the allegation against me involving James Howard and this civil motion hour and the affidavit. You're saying it was him that pointed you in that direction, and that's why you went that direction.
Well, I don't exactly know what your question is there.
Here's my question.
All right.
You're saying that Judge Grishop, Joe Grishop, gave you this affidavit, and you said, you testified, he was pointing you in that direction.
I think that's my interpretation of what he was trying to do. He was trying to say, here's what.
Was this before the grand jury returned the no true bill, or after the grand jury?
I'm not sure.
Mr. Johnson.
I don't think he gave me the actual affidavit until later. I think that he told me about it, and I wasn't really paying much attention to it.
It would have been, now you went to Scotland right after this grand jury
I
returned
did.
no true bill. And when did you get back from Scotland?
I think around May 19th. I went over, my daughter was over there in college, and I hadn't seen her for about a year. My wife and I went over and visited her.
Did he give it to you when you got back?
I don't know.
Now, Mr. Johnson, the secretaries that work for you in your office, are they all state-paid secretaries?
Yes.
Have you ever had them use their time as your secretaries to draft media packets to release to the media about me?
I talked about it. I know what you're talking about. You're talking about the email where I advised Joe Grisham and the sheriff that I thought you were probably going to try to indict us or something on when that special grand jury came in the 25th. And I based that on your explosive reaction to me presenting that case and then your subsequent actions on canceling my card and things like that. As it turns out, it came and went, nothing happened, so we kind of blew over because at that point, I was thinking we needed to prepare for a fight, and then it didn't materialize. So I said I was going to have him do that. I don't know if I did or not.
So you don't know if your staff prepared media packets and sent them out to the media?
Right. Well, they would not have sent them out to the media.
Well, who would send them out to the media?
They wouldn't have done it. No, I'm sure they did not send out media packets.
Why would you even have your state-paid employees using state computers and state paper draft a media packet and send it out to damage me? Why would you do that?
It wasn't to damage you. It was to actually act as evidence, and in this case, and to balance any action that you took. Now, as it turns out, you didn't take any, so we didn't do anything. All of this originates from my function as Commonwealth Attorney. And if you were going to try to do something to harm me or Joe Grisham or the sheriff, then I wanted to be prepared for it, and all of that relates to my work as Commonwealth Attorney. So the business about being state-paid employees is a false trail.
So it's part of your duties as a Commonwealth Attorney to have your office draft media packets to send out about me?
All I was having him do was put together a copy of the affidavit and a few other things that would explain what happened.
But what about advising Judge Grisham to get a hold of WYMT and have him do a story about it?
That's the same.
As a Commonwealth Attorney?
I think that sometimes it is, yeah.
Okay.
Let me see exactly what I said about
Hold
that,
on just
because
a second. I'll
you've
just
kind
do
of changed some of the things I've said a little bit. So could I see that?
Hold on just a second. I'm letting counsel look at it pursuant to the rule. May I approach the witness again?
You may.
Thank you. Excuse me.
So you admit...
Wait a second. I'm
Take your time.
reading this.
I'm sorry, sir. I thought you were done.
Judge Allred Walkies, what is that exhibit?
That is going to be Respondent's Exhibit D, I believe. Is that
Right.
correct?
What is it?
It is reported to be an email that Mr. Henry S. Johnson had sent to Joe Grisham on May the 12th, 2010, while Mr. Johnson was in Scotland.
Thank you.
Thank you. I'm sorry. I should have been clear. I was going to go into that in a second.
Okay. Is that what's your question?
Okay. Do you confirm that you sent that email from Scotland to Joe Grisham?
I did.
You confirm that you CC'd a copy of that to Martin Lippert?
I did.
Do you agree in that email that you're advising Joe Grisham to get the media to do a story on me?
I said it may be a good idea for him to, I said it may be necessary for you to arrange a press conference with as many media reporters as possible, including the Lexington paper, and let all this out.
Did you also say something you didn't know if they were going to do the story or not? Is that in that email too?
Yes. What I said was, I would not assume they were going to do anything with the story about the affidavit.
Did you contact them about me, trying to get them to do a story on me?
Well, about the affidavit. I had talked to one of the reporters about the affidavit.
Who'd you talk to?
I don't know. It was a young woman. You know, they turn over a lot at WYMT. I'm not sure what her name was. It was the one who did the story about all of this.
Was that your duties as a Commonwealth attorney to meet with reporters and spread out your theory of politics, why I would have done such a thing?
Well, if it's something that is part of if it explains an attempted misuse of the grand jury, I think yes, it can be. I talk to the press about cases all the time. There's nothing that says that I can't, and it's expected.
As your testimony as a Commonwealth attorney, you're allowed to have unfettered discussions with the media about this.
Did I say that? No, I didn't say that. Okay, unfettered discussions would be revealing confidential information and making improper allegations or insinuations and things like that nature, like that. This is not that. I'm allowed to talk to the press. I'm allowed to make certain kinds of comments. I'm allowed to go so far in talking about a case and no further.
This is Respondent's Exhibit E that I'm marking to let y'all look at, and I'll question if I can. Now, as far back as May 12, 2010, you would read the first two lines that email was sent.
Okay, first two lines. It says, Dear Joe, I have good reason to believe that on May 25th, Judge Allred will try to use the special grand jury that is still scheduled to report to indict you and also me and possibly the sheriff. It is important that we finish our own investigation of the judge's improper conduct before then and have all our documentation in hand. Okay, at that point then, it's apparent that at that time I knew about the affidavit and realized the significance of it. So by May 12th, I understood about the affidavit.
Okay. Now that you understood about the affidavit, going back to the letter of referral from Crick Llewellyn's office, which I think was the April 11th, 2008, Exhibit C, was it Response Exhibit C? Yes, Response Exhibit C. We've got a referral from Crick Llewellyn's office concerning James F. Howard. Is this the same James F. Howard that you have the affidavit and had been having discussions with him and his attorney about me at that time in 2010?
Okay. This is the same James Howard in whose case, which was before you in your court, Joe Grisham gave an affidavit saying that you had summoned him to your office and told him that you wanted him to rescind the lease to the same James Howard because you wanted to use it for a different purpose. That is the same one.
Okay. So you had been in contact with James Howard and his attorney since May 12, 2010 concerning the same matter that was referred to you by Crick Llewellyn's office in April 2011, for you to investigate concerning the improper use of public property by James F. Howard, involved in the same issues that came up in that affidavit.
That's not the same issue.
It's not?
No. The issue, the affidavit, the significance of that to me was that it served as your motivation for issuing the order on the 22nd, trying to slander the county judge executive. That's completely independent as to whether the lease that was the subject of the affidavit was a valid lease or not, or someone that should be criticized or whatever. And at this point,
have you taken any steps whatsoever, besides talking to the Attorney General's office about this matter, James Howard? Have you issued subpoenas? Have you had the police going to do investigations or anything of that nature regarding
well,
James F. Howard?
you're just blowing off the fact that I took it to the Attorney General's office. I took the auditor's report up to special investigations in the Attorney General's office, and because, again, it involves county politics and things of that nature, and I want to make sure that we have an outside supervision of the investigation to make sure there's no taint of local politics.
Why didn't you do that with the
well,
Chapman's Court?
let me finish this. I did talk to them about it also. Now, and I presented that to them, and I've been waiting to see what they're going to do with it. Now, I don't know if they're delaying because of the civil litigation that's going on, or what. But anyway,
Is this the same James F. Howard that called?
this lease has been in effect for years and years, though. It's not, you know, I mean, there's some cases that are urgent, and, for example, you know, rapes, murders, serious assaults, child sexual abuse. There's an urgent.
Toothbrushes and.
Pardon me?
Toothbrushes and toiletry missing from the Chaplain School building at Cold Iron. That's another high priority case.
No, I think it's not. That's what I'm saying. I don't think there's as big a rush on that as there is on one of those other cases that I just named.
Isn't it true, Mr. Johnson, that you're using this grand jury to try to intimidate Joe Grisham into changing his testimony back the way you liked it early on?
No, I've had no communication with Joe Grisham about this
Is
at
it
all.
true you attempted to contact her?
I did several months ago because I heard that he was behaving in a very, very stressed and paranoid fashion, and he thought that I was out to get him. And I saw him over at the Lou's coffee shop, or whatever it's called, the sandwich shop. And I told him, Joe, you need to talk to me, and you'll feel a lot better if you just talk. Really, you just need to sit and talk to me about this. Because I was going to tell him I'm not out to get him, I'm not plotting against him, and he can relax.
Is this the same James Howard, the one that you had to refer from Cricklewood Allen's office?
And as a matter of fact, Joe said that he would talk to me. But someone told him not to, I guess. But go ahead.
Objection, Your Honor, non-responsive.
Okay, about James Howard, go ahead.
James Howard. Are you aware that James Howard had contacted a magistrate, called his house numerous times at 5:30 in the morning, and told him that he had better vote for your office to receive $50,000 in funds for an assistant?
No.
Isn't it true?
He did not do that at my request, and I had nothing to do with that. Now, let me say that about the funding for the assistant.
Your Honor, if you please, before I ask him a question, he was going on soliloquy. I would like to
You asked him, Judge Allred, you asked him the question. This morning, Mr. Mando asked you questions. You went on forever. I'm going to give Mr. Johnson the ability to do the same thing. You asked the question.
non-responsive too, Judge.
He can answer.
Okay. The $50,000 that the fiscal court
No, my
paid,
objection for that.
the $50,000 that the fiscal court has given for several years now toward an assistant in my office was money that the fiscal court voted to give at your request, not mine, several years ago. And I very much appreciated that because we had a heavy caseload and that helped carry it. They've renewed it since then, and just since all of this came up, this year, the county judge executive, Joe Grisham, who is going to be a witness for you, told the treasurer to leave it out. And so I contacted some of the magistrates, and apparently other people did too. And they put it back in.
Another email here too, marked identification for responding to Z, E ready, E. This is one that you sent to. Marvin, if you would read the last two lines of that email.
I'm sorry, Mr. Johnson, who is that directed to?
That was directed to Marvin Lidford, the sheriff of Harlan County.
Read the last two lines of that email, please.
Okay. Okay, I said spending time on this will probably do more to ensure your reelection than shaking a few more hands. Please let me know everything. Thanks, Henry.
And go before that, the lines were there.
Okay, I know you were both campaigning, but by now the primary is either won or lost, and letting Russ succeed with a special grand jury and discrediting us would have a big impact on the general election.
What's the date?
That date is May 12th, 2010.
Thank you.
Why don't I read the whole email? It's short.
You also have
Would you like for me to read the whole email? Okay.
Okay.
All right, go ahead. Sure. All right.
Now, the question to you is this. If you were a judge executive and the Commonwealth attorney was sending you emails saying that the circuit judge is going to indict you, don't you think that would scare you?
Objection.
Yeah. That's, what kind of question is that?
The intent that you had to send these emails to the judge executive was to keep him scared and to keep him rolling with these allegations against me.
Well, actually, at that time, I was overreacting because all this had just happened, and then I was gone. We'd planned that trip to Scotland for a long time. It's the first time I'd ever been out of the country. And I got over there, and all this stuff hit, and then you have all these allegations going around. And I think I thought that you were planning more than you were. And so I overreacted. And I was trying to motivate him to go ahead and stay on top of things and make sure that we had the information we needed.
Were you aware that Gene Weaver from the Judicial Conduct Commission was going to come to Harlan while you were in Scotland?
No.
When did you find out he was coming to Harlan?
It was after I got back. I think the first time I knew about it was he called me to see if I was going to be around, maybe. Or I don't know if he just showed up or if he called me ahead of time. I don't recall.
When did you get back from Scotland again?
The 19th, I think. That's when I got back.
Had he contacted your office while you were gone?
I don't know.
Let's change gears a little bit. You said let's go back to the doctors. Is it true, Mr. Johnson, in the allegation involving Dr. B and Dr. Lawrence, that the defense attorneys were the ones who wanted to make a donation?
Correct.
The defendants.
That is correct.
That was not something that was hatched by me, or you, or anybody of that nature. That was the defense attorneys that wanted to do that with their clients.
They wanted to do whatever money they were going to lose. They wanted to do it as a donation rather than asset forfeiture or something that would not be tax deductible. They wanted to do it in a tax deductible fashion.
At any time, did Martin Woodford ever talk to you about some of the donated money going to a chaplain's school?
Yes,
And how many times did Sheriff Litford ask you about that?
several times.
In fact, didn't he kind of pester you a little bit with it?
A little bit.
Did you tell him yes or no?
I put him off on it. I thought that if he was going to give money to the chaplain corps, and I told him this, he should do it out of whatever asset forfeiture he received rather than the donated money, because he would receive the bulk of the actual asset forfeiture, and he can use that for law enforcement purposes. And we talked about this. He couldn't. There were certain things he couldn't use it for, but he could use it for office expenses and car expenses and stuff like that related to the chaplain's corps. And so I told him that I thought he should just go ahead and do it that way.
And you, like I, saw that as a major problem, money coming from a criminal defendant to the sheriff's office for his chaplain's corps.
I didn't really exactly see it as a serious problem. I thought that since he was getting all that asset forfeiture money, that it could be used better somewhere else.
So you didn't see an ethical problem with a criminal defendant making a $50,000 donation to the arresting agency's chaplain's corps?
In this case, since it was, I really didn't think of it. I just knew it was a bad idea, and I told him I didn't think they should do it that way.
So if he advised me that you said that was okay, he would have not been telling me.
That I said it was ethically okay?
You said it was okay for it to happen that way.
I think that, okay, the money was going to be donated to fiscal court, and they were going to use it, subject to your approval, in ways to alleviate drug abuse in Harlan County. Now, if the fiscal court was going to take $50,000 of that money and give it to the sheriff's office for the chaplain's corps, I don't think that's a problem. It would not be coming directly from the defendant. The money was going to the fiscal court, and its use was subject to your approval. And if some of the money was used for to alleviate drug abuse, the chaplain's corps might have a role in that. If the money was, I think that the fiscal court could have turned it all over to the sheriff's office if they'd wanted to use in drug investigations.
Is it your testimony, so you have no problem at all with that money going to the arresting agency in this criminal case?
Right. If it went through fiscal court. If the fiscal court chose to use it that way to address drug abuse in Harlan County, I don't think that would be a problem, because it was going to the fiscal court
Isn't it true that I never told you to put that specific language in the order?
I told you it was going to be in there. You did not say, I want this specific language in the order. But I told you, here's, this language is going to be
Did I
in
ever
there.
tell you to put that language in that order?
No, you didn't. You never told me to put those specific words in that order. I told you those words were going to be in the order, and you approved of it.
Now, after the hearing that we watched here earlier, the doctors, there were numerous orders drafted by my office after that hearing. Are you familiar with those orders?
And it, I know there were orders. I don't know which ones you're talking about.
Well, so I copy of all the entire paper.
This is just Dr. V and Dr. Alani, or is this just Dr. V? Both.
Our opposing counsel looks. There were numerous orders that I drafted after that. Are you familiar with any of those?
I can't, excuse me, I can't say specifically that you did draft orders. I know you drafted the one.
By my office.
Well, I know, by your office. I don't know what was drafted by you and what, your office and what was drafted by the defense counsel. I know that I think the last one, the amended order, came from you.
Are you aware that on one of the orders drafted after the hearing, there was something in that order that the defense counsel didn't want in that order? And they filed a
Yes.
motion to alter that, correct?
Correct.
And as it turned out, that was simply a typo or something that could be easily corrected, and you had no objection to correcting that. It was corrected.
It wasn't a typo, but I didn't have any problem with correcting it. Yeah.
They filed a motion to correct it.
Right. They filed a motion to correct it.
And I corrected that language on their motion and
Right.
with your agreement.
Correct.
And as soon as I entered that order that had the problem with it in January of 2011, January 26, 2011, defense counsel immediately brought it to the attention of the court to correct that,
Correct.
because it was a mistake that went in there.
Right.
When I did the order of March 1st, or the one order in March correcting the language, are you aware of any motions filed by defense counsel to correct that order that I entered to say that language
No.
wasn't true? Not aware of any?
I'm not aware of any, no.
Did you file a motion
No.
in the case to say that language should have been in there and this is not true?
I did not.
In any of the orders that I drafted, that were drafted by my office, did it ever say that the money had to be spent at Judge Always' discretion?
It said it was to be spent, I don't know, not by orders drafted by you, no.
Okay. Well, did you find it odd that I had done these orders after the hearing? This is marked as Response Exhibit F.
And Judge, those are various orders in the, I'll call it the drug case,
Yes, in
the 08, yes, Dr. V. Thank you.
Look through there. Are there any orders besides the orders drafted by the defense attorneys after consulting with you that have that language to be spent at Judge Always' circuit judge's discretion?
No, I wouldn't expect so. And the reason that I didn't file any motion to correct, well, never mind.
I move to introduce that as Response Exhibit F, certified copies of the entire file.
No objection, Mr. Chairman.
Thank you.
Save that, Mr. Now, you said there were 3 lawyers from Nashville in this case?
Correct.
Are you sure they're all from Nashville?
There was a Funk, there was I'm not sure they're all from Nashville. I think there were 3 from Tennessee and 3 from Kentucky. The ones from Kentucky were Katie Gillum, Lowell Lundy, and heck, that guy from over in western Kentucky, whose name I can't recall right now. And then I think there were 3 from Tennessee also.
So there were a lot of lawyers in this case.
There were a lot of lawyers in the case.
And most of them didn't come in much, did they? In other words, most of the negotiation that was going on either by telephone or email or something like that.
Well, mostly it was in person with Lowell Lundy. There were some emails and telephone calls.
And he would have to call and tell them what you all talked about, get permission from them.
I don't know. I don't know how they did that and what authority he had.
About it.
He told me he had authority to negotiate for both of them, so we negotiated.
Okay. Now, in regard to the special grand jury again, I want to go back to that for just a second. In regard to the special grand jury, did you tell anybody besides me, you said you told me about what's going on with the special grand jury, the investigation of Joe Grisham? Did you tell anybody else about the investigation of Joe Grisham before the case was presented to the grand jury?
I may have told my wife.
Was your testimony that the only person you told before presenting it to the grand jury about the investigation involving Joe Grisham was your wife, correct?
That's the only one I can remember. I may have told someone else about it.
Did you ever tell anyone specific details about an Attorney General's office investigation?
I may have.
Who would that have been?
I don't know.
Did you ever tell anyone that the sheriff's office came to you talking about trying to set Joe Grisham up with a girl by sending a camera into his apartment, into his office, rather?
I wouldn't have used that phrasing at all.
Are you familiar with Roger Sizemore?
I may have said something to him or to somebody else about the case. I don't know.
You normally tell, first of all, is Roger Sizemore an employee of the Commonwealth Attorney's Office?
No, he's not.
Is he a law enforcement officer?
No, he's not.
What does he do for a living?
He is a retired health department employee, an inspector for the health department or something like that, and he's retired.
Would you have told him about the Attorney General's office investigation of Joe Grisham?
I don't know. You mean after all this came out?
Before it was presented to the, you just testified, as you probably just told your wife.
I remember specifically, pretty specifically, I'm pretty sure I told her about it. Before it was presented to the grand jury, when it first came out, I think I told her about it. And during that week, I may have told other people about it too.
Did you make it a common practice to tell
No.
a citizen on the street about confidential investigations of Joe Grisham?
Well, it wasn't a confidential investigation. I mean, at that point, and I don't think that saying, look, there's going to be a no true bill because the investigation did not show any crime being committed.
Are matters that go on with the grand jury confidential?
Matters that go on inside the grand jury room are in fact confidential. This was not something that was going on inside the grand jury room.
Was it your plan to alleviate the publicity of this case by telling Roger Sizemore and other people about the investigation of Joe Grisham?
Well, I think telling him that there's not evidence that he's guilty of it, yes, does ameliorate. By this time, the publicity was already out.
Now, is it your testimony here today that the sheriff, Marvin Lidford, told you throughout this investigation that there was no case on Joe Grisham?
No, I didn't say that. When he first came in, he was excited, and he thought he had a case. And I think that was, well, I don't know. But anyway, I wanted to watch the tape. We watched it, and that's when I told him, well, it's something, but it's not enough. It does not show a transaction.
You testified that it was in the fall that he had brought this case?
I think so, yeah.
Was it in August, September,
I don't
October?
know. I do not know.
When did you decide, or rather, did Marvin Lidford continuously, when did he change? When did he tell you there was no longer a case?
Probably after now, I didn't really hear anything else about the case once the Attorney General's office stepped in until they concluded there was nothing there. I mean, I don't remember hearing much about it. I was not, kept closely advised or anything. I may have had a comment or here or there about how it was going, but I was not closely involved in that until after the Attorney General's office determined there was nothing there. I didn't know exactly how the Attorney General's office and the sheriff was working together until the very end, I think.
So how did you determine when the investigation ended if you didn't really have much of a conversation with the sheriff about what was going on?
Well, when the Attorney General's office documented that there's not evidence here and we're closing the investigation, I took that as meaning that it was done.
When did you find out he had changed his mind about the investigation?
I don't know exactly.
Did he ever tell you that he had changed his mind about the investigation?
Yes.
Was it prior to you presenting it to the grand jury?
Yes.
How soon was it?
I don't know.
Was it in the spring? Was it in the winter?
Well, it was presented in May, so yeah, it was. And the Attorney General signed off on it in March, so it was somewhere in that time period.
Now, you admit at your press conference that you had, did you have a press conference after the No True Bill was returned?
I did.
The No True Bill in regard to Joe Grisham.
Right.
And where was this press conference held at?
At my office.
And how many reporters were there?
There was one from WYMT. There was a reporter from the, let's see, no, there wasn't. Yeah, Jackie Cornett from the radio station showed up a little late. There was someone from the Harlan Daily Enterprise. I think there was a reporter from the Lexington paper. And there may have been somebody else that I don't recall.
And you admit that in this press conference you said you agreed with the special grand jury?
Yes. It's not an admission. It's a statement of fact. I've said it all along. I've never said anything else, and I haven't deviated.
This will be G, Respondent's Exhibit G. This is a digital recording of the interview. To save time, I just introduced that as an exhibit. Any objection?
I've not heard it, and I have no way to authenticate it at this point in time. What is it again, Judge?
It is the recording of Henry Johnson's interview post No True Bill, where he admitted that he agreed with the special.
I did not admit it. I stated it. I mean, I brought it up. It's not like someone said, admit this. I said, here's what happened, and I went through it for him.
Mr. Chairman, I'm not trying to be difficult, but I can't agree to admit that until I've had some other proof of authenticity or until I've heard it. I have no idea what's on the tape. I have no reason to doubt Judge Allred, but in my position, I at least have to have some way to authenticate it. If we want to reserve on it until later, I may be able to agree to it, but at this point, just having heard that, I can't agree to it.
We'd reserve on it because I agree with you, Mr. Johnson. You've not heard that.
Not that specific, no.
We'll get the computer set up and play it for you. I was just trying to save time with that. Okay. Now, Mr. Johnson, at your press conference, before we go to that, you indicated that the informant in the case, who was the informant in Joe Grisham's case?
Melissa Hensley.
Okay. And are you familiar with Miss Melissa Hensley?
Well, I know who she is, and she's been, as I said, she'd been through the drug court program before, and I knew that her brother was a state police detective.
Now, was she working for the Sheriff's Department trying to work off a drug trafficking charge?
Yes.
And what was she charged? Do you recall what the charge was she had?
No.
Some type of drug trafficking?
Yes, it was.
And you just testified that she went through the drug court program previously, correct?
Correct.
So this would have been her second felony charge.
Right.
Okay. You testified, right, there were pills obtained from somewhere by Mrs. Hensley, weren't there?
Yes.
And in that police report that I introduced, doesn't it say that they came back lab confirmed?
Yes.
And what day did those lab reports come back confirmed?
I do not know.
Would you mind looking into
Whatever's on them is when they came back.
that? Would help us. If you would, look through that response exhibit A. Are you familiar with those lab reports, Mr. Johnson? I should lay a foundation, I'm sorry.
Well, they're already in evidence. I don't think you need a foundation, but
I just want to make sure that you can testify about them. I know they're in evidence, I just want to make sure.
okay, let's see. Okay. Here's a report that, yes, it was found to contain, there was one blue tablet tested. It contained oxycodone, a Schedule II narcotic, and that was April 8th, 2010.
So, April 8th of 2010? Now, that pill was taken from Miss Hensley, is that correct?
Okay, I don't have personal knowledge of that.
What does the report say?
Well, the report says what it says. You know, I didn't do this report. I didn't prepare the report. And so, if you want to get the report in and ask questions about it, you should get the person who actually has personal knowledge of that. All I can tell you is, here's what the report says.
Okay, fair enough. You testified as the Commonwealth Attorney for the 26th Judicial Circuit, is that correct?
Yes.
And Miss Hensley, Miss E. Hensley, was trying to work her way out of her second felony charge, correct?
Correct.
And according to that police report, the investigating officer's report, controlled substances were in her possession, according to the report.
Right.
And did she sign some kind of agreement with the sheriff's office that she would cooperate and be honest and be fair and not violate the law during the time period she was working for the sheriff's department?
I don't know. I wasn't involved in any transactions or discussions between the sheriff's office and this informant.
Did you continue to prosecute her in the drug trafficking case that she was trying to work her way out of?
Yes.
And in fact, didn't I recuse in that case in May of 2010?
You recused at some time, yes.
And you continued in that case until December the 17th of 2011 when she entered a plea of guilty in that case, correct?
I remember that she entered her plea. I don't remember when.
Do you remember what you offered her on that drug trafficking case?
I don't specifically. There was some leniency involved in it, as I recall.
In fact, didn't you offer her probation?
I think I probably did. That's what I thought I had
Do
offered,
you
yes.
recall what you wrote in the Commonwealth's offer on plea of guilty?
I do not recall that.
I have certified copies. Her case. Marking this as identification purposes as respondent's exhibit, is it G or H? It's H. Okay.
This was the plea offer to Ms. Hensley.
This is AOC Form 491.1, Commonwealth's offer on plea of guilty, certified copy.
Thank you.
You're welcome, sir. And, do that. Also, we'll put another sticker. I'm marking order of probation, conditional discharge, certified copy. I'm marking it for verification purposes, response exhibit I. Now, Mr. Johnson, I'm approaching you with these two exhibits, H and I. If you would, please look at exhibit H. Are you familiar with that document?
I do. I mean, I signed it. I
Does
signed
your
it.
signature appear on that document?
It does.
Is there a section on those forms, Commonwealth's offer on plea of guilty, that says recommendations and the reason why for those recommendations?
Yes.
Would you please read what's on that form that you signed?
Okay, that actual part on the form is left blank, and however, down in the recommendations portion, it says that it's probated due to assistance given to law enforcement.
Did you write that in there?
Yes.
Can you explain to me what assistance Melissa Hensley gave to law enforcement?
Yes. This was, the Joe Grisham thing came up after she had already been working as an informant for quite some time. She had made several buys of drugs which had good videotapes and which resulted in convictions. You know, I mentioned before that the credibility of the informant is usually not good in these cases, and that's why we want a tape that clearly shows what's going on. And she did a very good job as an informant in going and buying drugs from dealers with a great videotape that showed that, yeah, they were selling her the drugs in other cases, not Joe Grisham's. And there was another reason that I gave her leniency also. And that is because I think there's something wrong with her mentally. Talking to her and when she testified, she would lie about things that were just ridiculous. Like, she said she couldn't take the polygraph because she had a pacemaker. And she said that it was back here, you know, that she'd had a pacemaker implanted there. She stated that she was in an auto accident and almost died and had to have a lot of plastic surgery. And that's why she wore so much makeup, and that she couldn't go to a tanning bed because the plastic from the plastic surgery in her face would melt. And she was saying things like that were just, why? You know, I mean, it's just really odd, really odd.
Was the Joe Grisham case the only case that you had to dismiss charges that she was involved in?
No, there was one other.
You signed the agreed order to dismiss those charges?
I did, because the defense counsel made a motion to dismiss because she was not credible and because the tape did not clearly show a transaction. And that was true, so I dismissed.
You said that you felt that she had mental problems. Did you advise the court that you felt this person had mental problems and ask for an evaluation?
No, that's it's the defense counsel who generally asks for a mental evaluation of their client if they feel that they have that kind of problem. You know, I'm just a layman. I'm not a psychiatrist. I'm not a psychologist, but
did you ever disclose to the other defense attorneys representing these other people that she had made buys from the circumstances surrounding the Grisham case and her inherent incredibility, lying, and
yeah, I think everybody knew about
Objection.
that.
Mr. Chairman.
He's answered the question.
the only reason I ask the question is it goes to validate his reason. If he felt that this person was inherently, withdraw the question. But you do admit you probated her?
Yes, I recommended probation.
Yeah. Because of cooperation provided law enforcement?
Right. She did a really good job on a lot of buys.
Do you remember a conversation you had on that same day, December the 17th, 2011, with Chief Deputy Winston Urie, when she was entering the plea that she wrote this Congress offer plea guilty?
I do not remember that.
Now let's go back to the testimony you gave earlier. Back when the special grand jury was meeting, was not meant to attend the case of the regular grand jury because of the meeting conditions. You said that I had sent a bailiff to summon you to come back to my office, correct?
Right.
Okay. okay? When you were coming back to my office, how did you get through the outer door to get into my hallway?
I'm not sure. I don't know if the bailiff keyed it open or if my card was working at that point and I did it or what. I don't recall.
It could have been you who went through the door with your own
Yeah,
car.
it could have been. I think at that point my pass card was still working.
And how far away is that door from my office door, would you say?
I would say probably maybe from here to the jury box,
Okay.
something like that.
When I was
Give or
talking to you,
take.
how far did you get in that door when I started talking to you?
I don't remember. I don't
Step?
recall. I'm sorry?
Just a step through the door?
I don't think so. I think I was farther in than that.
How far?
Well, I don't know how far. I wasn't measuring the distance, and this was a year and 4 months
Was
ago.
I this far from you?
You started out and you were walking toward me. So as far as,
How far of the time that you left was it?
you mean how,
Okay, let me phrase the question.
Yeah, please
What's
do.
the closest I ever got to you, Mr. Johnson?
5 feet? I don't know. I don't remember.
You don't know, do you, Mr.
No, I don't. That's what I said. I don't know. And you kept pressing me to come up with some kind of distance. I don't know, maybe 5 feet, maybe 8. I don't know.
Maybe 20,
You were closer than that.
15?
I don't know exactly how close you
You
were.
don't. Okay. And I didn't have my finger in your face either, did I?
Not in my face, no. You were waving it.
If somebody said that I put my finger in your face,
If you mean
they
right,
wouldn't know what they were talking
if you mean right up here like
Yes.
that, you did not do that.
about. Okay. And if someone said that I yelled the word shit at you, that didn't happen.
That could be.
You testified earlier. You said what I said.
Well, I didn't say that I was saying exactly what you said. The things that I testified about, I'm sure that you said to me. I don't know that
But you don't have any.
I was pretty shocked by it all, and I was pretty perturbed by it all. And that's one reason that later on I did overreact when I said that email. It was because I was very concerned, and because to have a circuit judge in a circuit where you have one circuit judge, and to have one blow his top at you like that and say those kind of things, and then persist in doing things like that, it's disconcerting.
Why did you send an email to my office on the Sunday evening before you presented the matter to the regular grand jury?
Just to let you know what I was going to do.
Have you ever sent me an email in your life? Besides
That's the only one I've ever sent you. I think it is. I don't know. I'm wondering how I got your email address. I think maybe there has been something else emailed between your offices, but it's not a common occurrence at all.
You sent it to my office email, correct?
Yes. I didn't know you had another email.
Did you expect me to be in the office on Sunday evening?
I did not know that was your office email.
When did you make the decision to present it to the regular grand jury?
Over that weekend.
So you issued subpoenas over that weekend for the regular grand jury?
Maybe it was Friday. I don't know. It was, shortly before. I was still thinking about it over the weekend. I know. I was thinking about whether I wanted to do that or not.
But you think it would have been common courtesy and a good policy to advise the judge, where you had talked about and agreed to a special grand jury, to let him know that you were going to skip that special grand jury, to give him a heads up, so he would
Well-
know to expect what's going on?
Except, at that point, I thought you were the one who had sent those emails out to the media. So I was kind of torn. Normally, yes, I'd like to give a heads up and so forth. But since I thought you were the one who was going to have a scheme thwarted and that you might react explosively at having your scheme thwarted, I was reluctant to do that. And I actually tried calling your house before I sent that email. And what?
What was my telephone number?
I don't know. I had to look it up or get it somewhere.
Where'd you get it from?
I do not recall. You've called me from your house before.
Now, Mr. Johnson, you filed motions to did you ever have retained the services of an attorney to assist you in motions to recuse me?
No,
Did you have an attorney hire an attorney for that purpose?
no.
Are you aware of any attorneys in Harlan that hired an attorney out of Louisville or any place else to assist in drafting motions to recuse me?
I don't know that. No. Now, I know that there were some attorneys who filed motions asking you to recuse. It was shortly after you took the bench. But I don't know if they used an attorney from Louisville.
Did Otis Doan ever help assist you in drafting any motions to recuse me?
I got copies of the motions that he and Johnny Turner had filed and used those in preparing my motion.
Did any attorneys outside of Johnny Turner and Otis Doan's law office fax documents to Mr. Doan's office that were delivered to you to draft the motions in question?
Not that I know of.
Are you an employee of the Kentucky Court of Justice?
I work for the Prosecutors Advisory Council, the Unified Prosecutorial System.
Is that an executive branch office?
Yes,
It's not a judicial branch office, is it?
correct.
You have no right to an access card in the Justice Center, do you?
I think that it is something that is at the discretion of the judge.
Isn't it reasonable to expect a judge to be afraid and concerned about people having access to his private hallway who he felt were lying to him and set him up?
Is that a hypothetical question?
Is it reasonable? If he believed that.
I think that's a hypothetical question, the way you're framing it.
Don't worry about that. I'll
Okay.
withdraw that question.
But I don't think that my card was revoked because of any fear on your part. It was temper tantrum.
Do you have temper tantrums, Mr. Johnson?
Occasionally, I have had them.
Do you threaten people?
Not since I was very young.
Did you ever threaten Judy Head?
No,
Is she a former employee of your office?
she is.
Is your testimony here under oath today that you did not contact her house after she left her employment approximately 1 week and threaten her?
Objection, relevancy.
Judge, what does this have to do with the charges that we're here about?
This goes to the truth or veracity of the witness, Your Honor. A lot of this is his testimony versus
He can
mine.
answer the question.
I don't remember anything like that.
Did you ever threaten Tim Hensley, Kentucky State Police, when he questioned you concerning the way you handle cases?
Objection, relevancy.
Pattern of conduct.
How does this go to the veracity of the witness, Your Honor? I've said I have temper
Is Mr.
tantrums.
Hensley going to testify?
He may, Your Honor, depending on how he answers the question.
I'm having trouble, Judge, understanding what this has to do with the charges.
It goes to the veracity of the witness, Your Honor. It goes to a pattern of conduct. Don't do what he says. If he gets mad, or threatens you, or lie about you, set up schemes, whatever he needs to do to get you in line. For instance, with Joe Grisham, the subpoena that was issued to the grand jury, that's exactly what I assert that is. In regard to Tim Hensley, I'm trying to elicit whether or not there was a threat made to him when he questioned the way he handled cases. In regard to Judy Head, when she didn't do what he wanted or did something that he didn't like, he would call and
Go
threaten.
ahead and answer the question.
Okay, what kind of threats are you talking about? Tell me what you think it is.
Tim Hensley ever questioned the way Kentucky State Police Detective Tim Hensley, the one that testified at the special grand jury, at the regular grand jury, did he ever question the way you handle cases?
I think he did about, oh gosh. This would have been in the early 1990s, maybe?
Did you threaten him?
Well, what do you mean by threaten?
Did you threaten to file a complaint on him?
I asked you that a minute ago.
Did you threaten to file a complaint on him?
No.
Did you threaten to notify his supervisor?
I threatened to point out to his supervisors shortcomings in his work.
You do a lot of that, don't you, Mr. Johnson?
No, I don't.
Objection. Mr. Chairman, if I can just add.
I do not.
hate to keep
Judge,
you
we're
up,
getting
but-
argumentative now. Just,
Yeah.
you know,
You
the
mean like-
question is, he answered the question.
Yes.
You mean like threatening to dismiss a lawsuit if the settlement doesn't meet your approval? You mean that kind of threat?
No? I mean,
How
like
about
I mean,
threatening?
like you're going to
How
file
about
complaints.
how about threatening to have someone investigated by the FBI?
Mr. Chairman, can we have a short recess?
Yes, that would be nice. That would be nice.
We're going to take about a 10-minute break. 10-minute break. The commission considered, I'm sorry?
Judge Coleman is
Judge Coleman is, okay. Break, we considered Judge Allred's motion to reconsider the charges count 14 and 15. The commission, based upon that request, has decided to reconsider that, and charges counts 14 and 15 will be dismissed. We thought it was, the reason we did it then, we thought it was important so we could potentially cut down on questioning and answers that may come up the rest of the day. So at this point, Mr. Mando, your next witness, please.
Mr. Chairman, just as a matter of convenience for witnesses, in light of the commission's ruling, we have just 2 minutes to release some witnesses.
Sure.
Who would be testifying about those counts. There's no need for them at this point.
You may.